Ano ba?
Live ka na.
Oh, is it live? Yan naman sa ano ba? Cellphone. Hindi natin alam kung naka-live na ako.
Ayan. Yes, you're
Okay.
live.
Okay, we're live. Hello, good afternoon everybody. Magandang hapon po sa inyong lahat. Maayong hapon sa inyong tanan. This is Ada again for the second part of my labor lecture series for the Philippine Association of Law Schools. As I said, this was a brainchild of our PALS president, Dean Mari Ananias, and spearheaded by Dean Al-Shuaid Ismael. So, magandang hapon po. During the last lecture that we had, I had some problems with my internet connectivity. Unfortunately, because of the ECQ, I had not been able to successfully contact our service provider, no? And I wasn't able to upgrade it. So, best efforts again. We will try to do as much as we can for these next 2 hours. I promise that we will tackle classification of employment, which we were not able to do the last time, no? And then we go into the right to self-organization, um, collective bargaining and appropriate bargaining unit, and then strikes, picketing, and lockouts towards the end of the 2-hour session. Probably we might even go beyond if my internet connection is not cut off again. Now, before we do that, I'd like to answer some of the questions that were asked last time. I remember right before I was rudely cut off, I was trying all 4 tests of determining the employer-employee relationship should be present. So as you might remember, I gave you a mnemonic, the mnemonic being Southwest Disaster Control, SWDC, selection and hiring. So the 4 tests of determining the existence of an employer-employee relationship would be selection, hiring. Whoever has the right to select and hire you, in all probability, is your employer. Now, wages, W stands for wages. Whoever pays you the wages, in all probability, is your employer. Dismissal, whoever has the power to dismiss you, in all probability, is your employer. And the last and the most important test of all is the control test. And I did say earlier that the control test is the most determinative factor for determining the existence of an employer-employee relationship. So, the question was, would it suffice to establish the control test to determine employer-employee relationship? Sabi nung isa dito, minsan po kasi hindi makita yung tatlong ibang elements. The answer is yes. The control test is the most determinative test. In fact, for as long as you can prove that one party has control over the other on the way that the work is supposed to be done. If I were to control the manner by which you will do the work for me, and you are able to prove that, then an employer-employee relationship is deemed established. Okay? You don't need to prove anything else, no? The most important test is the control test. Of course, the other factors would be important, but the most important, as I said, is the control test. Now, another question was, at this time of COVID crisis, can an employer of a vital industry such as power industry demand from its employees to be separated from their families and be quarantined at work for more than a month. I'd like you to check your Article 89 and Article 92 of the Labor Code. You can apply it by analogy. The employer can actually require the employee to go on emergency time work and to work on their rest day. So at these times no, of emergency, there is a need for vital industries to be kept running no, and in operation because it is vital to the economy and or for the supply chains to be to ensure continuous uh, uh, the continuous work for all the elements in the supply chain, then the employer may require the employee to work. But of course, they have to be paid, the proper remuneration as may be provided for below. But at this time, kasi, no, you can only do so much. 1 month, I do not know if they can actually go on, the whole 1 month period. If at all, what I heard in the United States, there were some factories that actually did that, but the employees were actually properly fed. They were given all the, all the food, all the perks. The families were allowed to at least call them or use the internet so that they can regularly contact each other. Sometimes at this like in COVID thing, no, minsan the higher purpose is more important, no. So yung tanong pwede lang i-require, yes, there is some basis under the labor code. They have to be properly remunerated for it. Okay. Now, are there cases when even just proving there is control is sufficient? Yes. Okay. So it's almost as the others. Okay. So let's start with our subject matter for today. No, I promised that we will start where we left off, and this is in respect of classification of employment. Now, during the last time, I told you that classification of employment is part of management prerogatives. And if you will remember, management prerogatives from a very simplistic viewpoint is the discretion of management to determine how to operate the business. Okay? Now, in operations of the business, sabi ko, para mas madali no, to engage each other. Medyo mahirap din kasing nag-uusap dito lang sa harap ng computer. No? It would be easier if we were to think of this situation where this is a company. So the last time I said parang ginawa natin COVID school, no? COVID school or was it COVID cafe? Now, in any event, let's call it COVID cafe. So I'm your boss chief and you are all my employees. Now, part of management prerogatives, because I put in the capital, I have a right to determine how to dispose of that capital and how the variables of the operations of the business so that I will earn some kind of profit. No? Now, part of that is also to determine, as part of my management prerogatives, how many I will hire. How many of you out there will I hire for this COVID cafe? And concomitant to that, what positions will I give you? And how much will I pay you? And what kind of classification of employment will be given to you? No? So, depending on our capabilities, then I will get general manager for the COVID cafe. I will get an operations manager. I will get an HR. I will get the finance person, etc., etc. And then I will get a barista. Okay, that's part of my management prerogatives. Now, the part of classification of employment is also required. Why? Because in that sense, in the classification of employment, one can determine the benefits that may be given as well as the exercise of political rights within the company. Now, preliminarily, let us just say, no, and let us disabuse your minds. In terms of minimum standards, the rule is that every employee is entitled to the minimum standards provided for by law under the labor code, except when it is explicitly provided in the labor code that you are not entitled to it. So the general rule is you are entitled except when you explicitly excluded. No? So yan yung mga labor standards. Now, in terms of in terms of classification of employment, there are two tiers or tiers in the classification of employment. One is in respect of the nature of the job. So you have in your slides, no, and I'm hoping that you were able to get a copy of the slides which were uploaded earlier at around 10 o'clock by Dean Schwade, no. You have 6 classifications of employment in accordance with the nature of the job which you will be assigned. So these are regular, probationary, term, project, seasonal, and casual. Now, another kind of classification of employment is in terms of the ranking. Ito yung managers, supervisors, and rank and file. Now, that particular classification, on the other hand, is important for purposes of determining whether or not they can join a union or they cannot join a union. Okay. So, mamaya natin pag-uusapan yun pag pumunta na tayo dun sa aspect ng self-organization. So, let's go for classification in terms of the nature of the job. Okay. So, general rule. Tandaan nyo palagi yung general rule. An employee is deemed regular. The law presumes that the employment is regular if the job for which you were hired is necessary or desirable in the usual trade or business of the employer. Okay? That's found in your Article 295. So, take a look at your Article 295. Makikita niyo doon, it sets the tone. The first phrase actually is the tone. It is mandatory. Bakit? Sabing ganyan. The provisions of a written agreement notwithstanding, and regardless of the oral agreements between the parties, the employment shall be deemed regular. So kahit anong pinag-usapan natin, okay? Kahit anong pinag-usapan natin, or kahit inulat yan sa kontrata, employment will be considered regular for as long as the job for which you were hired is necessary or desirable in trade or business of the company. Now you have to look in terms of what is the main business of the employer company. So here, in the context of COVID cafe, what would be a regular job? A regular is a job which is necessary. Okay? We cannot operate as a cafe without a job. So ano yun? So yung barista, no? O yung mga waiters. Okay? Yung kahera. Now, in terms of, let's say, a school, sino yung regular doon? This is a job without which the school cannot exist. So, teachers, no? Yung registrar. Now, however, the law also says, or desirable in the usual trade or business. Kasi necessary or desirable, hindi sinabing necessary and desirable. So, what is desirable? It means that it may not be necessary, but it is desirable in the usual trade or business. It may make the service or the work that you do or the service that is being offered to the general public better. In COVID cafe, let's say for example, what is a desirable job? Na talaga necessary doon, no? Ano 'yon? Yung valet, no? Yung valet driver. Kung halimbawa high-end ka na cafe, kasi mahirap mag-park, so you get valet driver. Do you need the valet driver? regularly in a cafe. No, you don't need that. But we want to make it easier for our customers to come in. That's why we get a valet driver. So that could be a regular job because it is desirable to do while trade or business of the COVID. Okay? Now, take a look at your Article 295 in your third slide. So sabing ganyan, in the first paragraph of Article 25 of the Labor Code, you will already see there are three classifications of employment already stated there. So the first is regular employment. However, it says there also that there is project employment and seasonal employment. So sabi dyan ganyan, okay, where the employee has been engaged to perform activities which are usually necessary or desirable in the usual trade or business is a regular job. Except, sabi ganyan, except for project employment or when it is seasonal employment. So what does it is in the same paragraph. Project employment and seasonal employment could be actually a regular job, but by the very nature of their employment, they are placed on a season-to-season basis or on a project-to-project basis. Okay? Now, what is a project employment? Ang pinakamagandang example of project employment, which is actually a regular job, no? But put in a project-to-project basis, are those in the construction industry. Okay? Bakit? So, sabihin natin may construction company dito. But it is not always that there is a project, a construction project, lalo na yung mga liit na contractors, no? Halimbawa, mga bahay-bahay lang yung ginagawa, hindi yung mga malalaking DMCI or Ayala. Now, halimbawa ako maliit na contractor lang. Question, if I were to get a carpenter, can I make him regular? Yes, of course. Will not refuse, In fact, they will say, thank you very much that you made them regular employees. Question, but can I also make them project employees? Yes, I can make them project employees for as long as at the time of the employment, when I hire that particular carpenter, he is informed of the project nature of his employment. Okay? Now, why is project employment allowed? Because it recognizes that in reference to certain kinds of businesses, the jobs will not always be there. Okay? So, project to project basis, hindi naman palagi meron akong bahay na gagawin. So, kukunin ko yung empleyado for a project to project basis. His employment with me is coterminous with the project, meaning to say, when the project is completed, then the employment of that particular carpenter is likewise completed. We will go more in detail later with respect to project employment. I'm just going through the overview muna. And then you have seasonal employment. Ganon din yon. So what is a good example of a seasonal employee na actually regular yan pero put into season? Yung sa farm, no? Pag farm, i-hire ko yung tao bilang harvester, no? So, dalawa lang yung kanyang planting season and harvesting season. In the meantime, between the harvesting season and in the planting season and the harvesting season, anong mangyayari? Wala siyang gagawin. So kaya ko kukunin yan on a seasonal to seasonal basis kasi doon ko lang kailangan sa planting at ko lang kailangan sa harvesting. So that is a seasonal employment. And last classification under Article 295, casual employment. Okay? In casual employment, it says there, if you are, this is a phrase, it says there, if you are not project, if you are not seasonal, then you are classified as a casual employee, no? However, even if you were hired as a casual employee, that casual employee continues, render service for at least 1 year, 365 days, at least 1 year, whether the service is continuous or broken. Pag ng 65th day, he will be considered as regular for as long as the activity for which he was hired continues to exist. Okay? So he becomes regular for as long as the activity for which he was hired continues to exist. Now, there are two other occasions of employment which is not found under your Article 295. One is probationary employment, which is found under your 296. Now, in this, probationary employment presumes that this is actually a regular job. However, the employer is allowed to test employee for a period of 6 months maximum, no? As a general rule, 6 months maximum. For the employer to determine whether or not this particular person has qualified, no, as a regular employee in with the standards made known to him at the time of hiring. Okay? Now, and then the sixth classification of employment is not even found in the labor code. This is what we call the fixed term employment. No? Now, if you were to read the Supreme Court decision in school, no? The Supreme Court here made a very exhaustive discussion, well researched, very comprehensive. And it appears from the research of the Supreme Court that term employment was inadvertently omitted when they codified the labor code. Okay? So meron ng law on term employment dati pa. Yun nga lang nakalimutang ilagay sa labor code. So the Supreme Court in the Brent School case actually stated that there is no indication that there was any intention to consider or to outlaw term employment because this is simply a meeting of minds. No? Okay, so let us discuss more fully our framework. No? So general rule, employment is regular. So kung halimbawa walang kontrata at hindi natin pinag-usapan, i-hire kita, barista, pasok ka dito. Ang presumption dyan, regular employment. Burden of proof now is upon the employer to prove that the employment is other than regular. So, kung sasabihin ko, ay, hindi yan regular, hindi ko siya hinire na regular. Hinire ko yan as probationary. The burden of proof is placed upon me to show that he is high probationary basis. So what would be the best proof? Definitely, that is why a written contract is actually used by the employers to show that it is an employment other than regular employment. Okay? So if it is either project, probationary, term, casual, or hire pala kita on those other classifications, then the burden of proof is upon me to show that. Okay? Otherwise, kung wala, yung presumption is employment is regular. Okay? Especially so where the job is necessary or desirable in the usual business of the employer. Okay. Now, then we go into the exception to Johns. So makikita nyo dito sa chart na binigay ko, no? Probationary employee allowed to work after probationary, etc., etc., etc. So we'll go into more in detail later. Okay, so now let's take a look at probationary employment kasi sinimulan ko na rin pala. So again, what is probationary employment under Article 296? 296 talks about probationary employment, but this presumes that this is for a regular job. The probationary period is generally for a period of 6 months. No? Now, the peculiarity of probationary employment is that I should have informed you. If I were to hire you as a probationary employee, I should have informed you what are the standards for regularization that I will need to assess you before you can be regularized. So, in short, I must make to you that you are placed on probation and I will assess your performance, in accordance with standards or regularization which made you at the time of your hiring. Okay? Now, these standards are usually placed in siguro sa mga manuals, no? Bibigyan ka, halimbawa, code of conduct. Ayan na. Ito ngayon yung iyong mga gagawin. These are what I need from you. Now, that's already informing you of what the standards are. Now, question. If you were a probationary employee, the law says 6-month period. Question. Can I put you on a probationary period for, let's say, 1.5 years? You are a barista. Pwede ba yon? Sabi ng batas, 6 months lang. Pero hindi, 1.5 years. Tatanggapin mo ba yan? Now, in these instances, there are options. But the burden of proof again is upon the employer to show that there is a need for a longer probationary period and we agreed to that longer probationary period at the time of hiring. So, halimbawa, sinabi ko, barista ka nga. But this COVID cafe is a high-end cafe and I will need you to speak French and Chinese. So you will be trained in those two languages because most of our clients, most of our customers speak in French and in Chinese. So I will have to ask you to learn those languages before you can become regular. Tanong, tatanggapin mo ba yan? Okay? That's the reason why I want to have a longer period. No, I want to have a longer period because you will have to be able to have facility. Now, if you agree to that, then you will be bound by that agreement kasi ilalagay natin yan sa kontrata. No? So, that's one exception. No? General rule, 6 months. First exception, if we agree to a longer period and I, as the employer, can justify the need for a longer period, and you agree to that, then so be it. Okay? You will be bound by it. Now, that's the case of Verbizer versus GTE Yellow Pages. Second, what if in this instance, probationary period tatapos na, no? You're already for 5 months and 3 weeks. So next week patapos ka na. And I told you, I'm sorry. I'm showing to you probationary appraisal sheet. I'm sorry, but your performance evaluation is bagsak. You did not make the grade. I will have to let you leave. Question. If you asked me, on the other hand, kawawa naman po ako, hindi ko kayang walang trabaho kasi marami akong give me a second chance. If I agree to have, to give you a second chance and extend it, then that will likewise be binding upon both of us. Okay? So that is the second exception to the 6-month general rule of a probationary period. So there is an agreement to extend the probationary period. In all probability, because matatanggal na sa trabaho, that particular probationary employee did not make the grade. Okay. Third, the third exception is with respect to teachers. Okay? The law mandates a 3-year probationary period teachers, no? Whether it's a basic ed teacher or tertiary college teacher, then that is the law and that is complied with. Of course, if the employer, on the other hand, question lang, can the employer shorten the probationary period? Example, itong hinire kita na barista, within 3 months pa lang, my God, galing-galing mo na mag-French tsaka Chinese. Can I already make you regular? Yes, I can make you regular. Why? Because the probationary period is not necessarily 6 months. No, that's just the maximum. But I can shorten it if I'm already satisfied with your performance. So, because you had learned quite quickly, I don't want to let you go. No? So I will make you regular. That is also a prerogative of management. Now, what about probationary contracts with a term? Halimbawa yung mga long-term contracts, in some of the companies kasi, pagka halimbawa probationary contract ka for a longer period, sabihin natin 1.5 years, nagbibigay yan ng kontrata for 6 months, first probationary, Pro B1, 6 months, Pro B2, another 6 months, Pro B3, another 6 months. Okay? Now, you cannot go B1 without, you cannot go to Pro B2 without passing Pro B1. You cannot go to Pro B3 without passing Pro B2. Okay? Now, let us assume that you pass Pro B1 and then you flunk Pro B2. You ask me, ma'am, bakit yung iba kong mga kasama may Pro B3 contract na, ako wala pa? Bakit sila na ibang barista, binigyan niya ng Pro B3, ako wala? And I said, oh, di ba Pro B2? Natapos na yung Pro B2, you don't need to go back to work anymore because it means that our contract had already ended at the expiration of the Pro B2 contract. Sa tapos 6 months, sorry ibig sabihin hindi na nag-comply sa ating requirements, bagsak ka pala iho. Pwede ba yon? Is that allowed? That I will now say, oy, your contract just ended. Anyway, you know naman, every 6 months, hindi ka binigyan ng Pro B3 contract, I am not under any obligation to offer you, I'm not under any obligation to rehire you for a third time because I found your performance in the probationary second period bad. Question, is that allowed? Can I let you go by the mere pretext that your Pro B2 contract had expired? In short, the term period there had already expired. Pa yun? Now, sabi ngayon ng Supreme Court, the Supreme Court had already overturned previous case. Dati kasi, the Supreme Court said, term contract yan So, yung Pro B2 contract, nung end na, the employer is not under any obligation to retire. The Supreme Court overturned itself in the case of Yolanda Mercado versus AMA Computer Center for Parañaque. The Supreme Court here said, you must remember, this is still a probationary employee. Although his probationary employment was cut down into several stages. So therefore, the term nature of that contract should not be given primordial consideration. Rather, sabi ganyan, the probationary nature of the contract should be given primordial consideration rather than the term nature of the contract. So, practical terms, what does that exactly mean? It means simply that as a probationary employee, you have the right to know why you fail to comply with the standards, the reasonable standards made known to you at the time of your employment. In short, hindi na lang pwedeng sa employer, sorry, hindi ka na kailangan pumasok next week, expire na yung term mo. Hindi. Because you have a right to know, what happened? I'm supposed to be probation. No? So, you're supposed to let me know, okay, where did I fail in my standards, in the standards, okay? So you have to be notified within a reasonable time of your failure to comply with the reasonable standards made known to you at the time of the employment. So that is now the case of Yolanda Mercado, which has been reiterated in several cases. Now, mostly these are is about schools, but it can be applied analogy to other kinds of uh, things, no? Especially halimbawa yung matatagal yung probationary contracts. Okay. Term employment. Napag-usapan natin ngayon yan, no? Yung term employment. Those who are hired for, nakuha niyo ba to? Yung pinadalang mga, yung slides, no? Andito na tayo sa page 3. Okay. Term employees kasi, these are employees who are hired for a specific period. The employment ends upon the arrival of the day certain indicated contract. Okay? So kung halimbawa usapan natin na hanggang May 31, 2020 yung ating kontrata, pagdating ng May 31, 2020, our employment relationship will end. Okay? Now, how do you distinguish that with project employment? Ganito kasi ang project employment eh. Ang project employment is tied to a specific project. For example, I hire this particular person in COVID Cafe for the let's say computerization of our cashiering, yung cash flow, okay, yung finance aspect, yung kahera at saka yung perang papasok, yung perang lalabas. Okay, so meron akong pinagawang program ko doon sa IT na yon. I want you to create a program for COVID Cafe that will address the finances coming in and the finances going out, the money coming in and the money coming out. Specifically for a period of 6 months from January 1, 2020 all the way to June 30, 2020. So 6 months na yan. Now, in a project contract, it is the completion of the project which terminates the employment relationship. Which means, therefore, if the project completed by this particular person, bawa sabihin natin pangalan niya si Paulo. Paulo finishes that project within a 4-month period. Then, the project is deemed completed and hence the project contract ends and hence the employment relationship is likewise terminated because he has nothing else left. Okay? Now, the term that is placed in that project is merely descriptive of the project, but it does not define the project itself. Okay? It is not determinative of the employee relationship. Let us contrast that with term employment. In term employment kasi, the more important thing there is the period itself. Sinabi ko, for a 6-month period from January 1, 2020 all the way to May 31, 2020. Whatever job I ask you to do there doesn't matter. What's important there is the job, the time frame. So, halimbawa, I told you, ikaw, gawin mo tong program na to. Yung money coming in, gumawa ka ng Excel file, money coming in, money coming out. From January 1 to June 30, 2020. Okay? So now, kung halimbawa, hindi niya natapos to, term employee to hindi niya natapos yung Excel file na yan ng January 30, 2020, is his employment deemed terminated? Sir, yes. Bakit? Because this is a term contract. It doesn't matter what the job I gave. Okay? It doesn't matter. Kasi sinabi ko hanggang June 30 lang eh. Yung ibinigay kong trabaho, that is just ancillary. But I wanted you to just do this. It was not a project itself. Okay? I did not give you a project. I wanted you to work for a specific period. Nagkataon lang, ito, gawin mo Excel file. Whereas, yung isa, ito ang project, tapusin mo yan. So, let's say for example, yun naman yung project employee. Halimbawa naman, nangyari, hindi niya natapos on June 30, 2020. Hindi niya natapos yung program. Question, is his employment deemed terminated? It's a project employee, and he did not finish that particular project. Answer, no. His termination, he cannot be considered terminated. Why? Because the project to which he had been given has not yet been completed. So therefore, his employment is not deemed terminated because he's tied to a project. He is required to finish the project. So kung lumampas man lang yan, then it will be extended lang because the project has not yet been completed. Okay? Now, I want you to memorize what are the indicators of project employment for one to have a valid project employment, no? Kailangan kasi talaga mag-comply ka, no? To number one, the employee must be informed specifically of the project. There must be a project which specifically says what the project is, what is the name of the project, what are the particular periods, no? Ito yung tinitingnan namin mga time frame ng project. Now, the duration is made known and clear to the employee. The work that the employee will perform is in relation to the project. Now, di ba sabi ko sa inyo, pagka construction worker, pwede din talaga na in between project siya. So halimbawa, yung contractor kanina, no, maliit lang. Pero ng bahay natapos last week. Tapos in 2 months, meron na naman ako ng bahay na i-repair. I can get the same person, but I can put him on a project-to-project basis. That for carpenter, I can put him on a project-to-project basis. Am I required to pay him for work in between those two projects? Answer, no. Why? Because it's no work, no pay in between projects. He has no project in between. So therefore, I'm not required to pay him. No? Now, in the meantime, in between projects, that particular carpentero, can his services to other parties. Now, if dumating na yung isang project at nagkataon open siya, then I can hire him under a project contract. Now, in order for that person to remain purely a project employee, I have an obligation as to file a written termination report to the Department of Labor at the end of the project. Within 1 month from the end of the project, I have to report that to the Department of Labor and submit the termination reports may forward sa Department of Labor. So, the law now says, and this is important for them to be considered really project, there should be as many project termination reports as there are projects to which he was assigned. So let's say, for example, there was this guy, itong karpenterong to. I hired him for 10, okay? 10 projects as a carpenter. Project 1, Project 2, Project 3, Project 4, Project 5. In all of these projects, I filed a termination report with the Department of Labor. So, question, what is his status? Has he become regular? No. Why? For as long as all of the elements are complied with, that is a project employment pa rin. Okay? He has not become regular. Bakit? Kasi pinadala termination report yung Department of Labor. Question, what if Project 6, 7, and 8 nakalimutan kong i-file yung termination report? Tapos, naglagay na lang ako ng termination report nung nag-project 9 and 10. Tanong, itong karpenterong to, regular pa ba yan? Regular na ba yan? O project pa rin? Sabi ng iba, Ma'am, project pa rin kasi nung pinalagyan niya ng project employment, nag-submit ng termination reports. Butas eh. Butas. So, in this instance, dahil nabutas siya, hinabol na lang ng project 9 and 10, sa totoo lang, he became a project employee as of the 6th project because the termination report was not sent and not submitted to the Department of Labor. Remember, the burden of proof is always upon the employer. So, again, remember, most important factor in determining validity of project employment is whether or not there were termination reports submitted by the employer to the Department of Labor at the end of every project. So, for every project, there must be a termination report. Otherwise, pagka nagkulang, becomes a regular employee. Okay? Question. May a probationary employee, kanina, may a probationary employee be converted to project employment? So, example, itong barista, 1.5 years na. Okay? Proby 1, Proby 2, Proby 3. Marunong na siya mag-French, marunong siya mag-Chinese. So, ginawa ko na siyang regular employee. Magaling pa mang barista. Nung nag-end na yung Proby 3 contract niya, ang binigay ko sa kanya, project employment. Oh, ito ha, for a 1-year project, ilalagay kita dito sa aking bagong cafe, sa Merce Cove Cafe. Nandito sa BGC. Doon kita ilalagay. Tanong, will that be allowed? Answer, no. Why? Because once they pass the probationary period, in accordance with the reasonable standards made known to them at the time of hiring, the employee becomes regular as of the day after the probationary period. Okay? So, hindi pwede na bigyan ko ng project employment because the promise was once you pass the probationary period, you become regular. It cannot be any other. Okay? Now, seasonal employee. A seasonal employee is one who is hired for work or services which is seasonal in nature. So I told you earlier that the employee in a farm is a best example of a seasonal. Why? Because the farm, yung magsasaka doon, sa totoo lang, that is a regular job because it's necessary or desirable in the usual trade or business of the employer. However, I hire him only in a particular season. As I said, planting season and harvesting season. Yung planting season, sabihin natin, January to March. And then harvesting season is October to December. So doon lang seasons na yon ko siya nakahire. And in between, from March all the way to September, wala siyang trabaho. Okay? Do they become regular? General rule, no. If I hire them for season to season only, they are purely seasonal employees. Okay? However, there is now a new trending. The Supreme Court said, in several cases na, in the trend, no? There is now a category called regular seasonal workers. And what do we mean regular seasonal workers? Now, these are seasonal workers who have been hired regularly for the same seasons for a long period of time, for several seasons, doing the same job or activity. So magsasaka siya, magsasaka siya for the planting season and then magsasaka uli siya for the harvest season. Let's say for 10 years. Question, what is the nature of that classification particular employee? He is considered a regular seasonal worker. Okay? Now, what do we mean by regular seasonal worker? What does that exactly mean? Halimbawa dito sa hacienda, meron talaga akong regular workers. meron silang mga benefits as a regular employee. May CBA kami of rice every month that you work. So, kung regular employee ka for 12 months, may 12 sacks of rice ka. 1 sack for every month. Question. Ikaw ngayon yung seasonal worker. Hinahire kita for the planting and the harvesting season. Question. Will you be entitled to that? And you are already a seasonal worker because you've been working for me for 10 years, huh? Okay, now, question. Will you be entitled to that 1 sack of rice for every month that you are hired during the planting season from January to March 2020? In short, are you entitled to the 3 sacks of rice? Yes or no? Answer? No, you are not. Bakit? The Supreme Court said in the case of Universal Robina Sugar Milling, no? Sa benefits, you are considered seasonal employees, regular seasonal employees are entitled to the CBA benefits that are given to regular employees. Okay? So dito, they are regular seasonal workers but you have to distinguish them from a real regular. Alam mo, minsan ang gulo na, no? Pero dito kasi you will have to remember, no? When you say regular employees, the presumption is that they're working continuously for a period in all that year. So 12 months in the whole 12 months in the whole year. Whereas in seasonal, 3 months lang. Okay? So that's the distinction that was made by the Supreme Court in the case of Universal Robina Sugar Millings versus Encabati. Okay? Now, casual. Casual employees are those who are hired to perform work or services which are not necessary nor desirable in the usual trade or business. Not necessary or in the usual trade or business. Okay, sa COVID cafe, ano ang pwedeng casual worker dito? Yung painter, yung nagpe-paint ng ating walls, okay? Or yung carpentero, that is not necessary in our usual trade or business. So I can hire them on a casual basis. Okay? So these are merely incidental. However, the law says, again, if that particular employee has rendered service for at least 1 year, whether continuous or broken, then he becomes regular for as long as the activity for which he was hired continues to exist. Let us put it to practical terms. Sabi, madali lang yan kung continuous eh. So, from January 1, tapos nakita ko January 2, nagtatrabaho pa rin continuously. Ibig sabihin naging regular na yan. Kahit painter lang siya. No? Bakit? Ano yung pinipaint niya? Of the following year. No? So, January 1, 2020. Nakita ko siya January 2, 2020, 2021. Oh, considered regular na yan. Pa siya na siya ng 1 year, continuously. Ano bang ginawang trabaho niyan? At bakit isang taon painter sa loob ng aking cafe? Kasi sabi ko, gumawa ka ng maliliit na polka dots doon sa wall. Punuin mo lahat ng walls ng polka dots. So isang taon niya, yun ang trabaho niya. Maliliit na polka dots, micro polka dots for 1 year. Pero hindi ko siya kailangan. Yun lang ang trabaho niya. Casual siya, correct. But he now became regular because he had worked 1 year. Question, paano kung putol-putol? Halimbawa, ito naman, nag-polka dot siya. Okay? 2020, ginawa niya for 5 months, polka dots. 2021, 3 months. Ginawa man niya lahat ng polka dots, ginawa niyang triangle. Okay? And then sumunod na taon, 5 months plus 3 months, sinabi ko, uy, magtrabaho ka are. Okay? For 5 months. Question, at the end of that third engagement in 2022, where he worked for 5 months again, has he become Answer, yes. Why? Because the work that he did cumulatively for 3 engagements, first 5 months plus 3 months plus another 5 months equals 13. Therefore, he has already gone beyond the 1-year period, in which case he is considered regular for as long as the activity for which he was hired continues to exist. So, ibig sabihin, for as long as meron akong pinapagawang painting project, painting work sa kanya, he is regular. Tanong, paano kung paiba-iba? Paano kung paiba-iba? Painting siya na, tapos ngayon, ginawa siyang painting, tapos ginawa siyang driver, tapos ginawa siyang dishwasher. Tanong, anong kanyang classification? Casual o regular? Ha? Pareho-pareho. Regular. Bakit? Lumampas na siya eh. Lumampas na siya ng 12 months. Okay? Lumampas na siya ng 12 months. Klaro? Okay, that ends our discussion for classification of employment. Now, what meron bang questions dun sa mga not much?
Not related sa...
Sorry hindi ko nakikita yung mga yung pangalan to, yung inyong mga comments kasi aking setup medyo malabo. Alam mo namang low tech ako. Okay. Now, let me just check. Regarding payment of 13th month pay for 13 years after the decision, still constant. Naku, mukhang hindi ko maintindihan yung question nito. Babalikan ko na lang. Yung non-payment of 13th month pay, 13 years, hindi pinayaran yung 13th month pay. Are you entitled to it? I don't really, if I understood it correctly, you're now claiming your 13th month pay after 13 years. That would have prescribed. The prescriptive period for monetary claims is only 3 years. Unless,
already decision.
merong decision sa Supreme Court
Not awarding.
na hindi, I don't, kulang yung question dito, baka hindi complete yung facts, no? So, let me just get back to it and I'll just send you a private email na lang siguro. Okay. Now, let's now go into unionization. Okay? Right to self-organization. Now, this is the political aspect of labor relations. The reason why you want to organize yourself is because you want to have better bargaining leverage with me. Remember, sa simula, the last time when we talked in the first part of my lecture, we were talking the interest of management as against the interest of you people as my employees. What are your interests? No? Let me just put it in the context of a particular situation. Okay, COVID cafe, no? Sabihin natin na ako, as your boss, your employer, I had been complying strictly with all of the provisions in the labor code. All the minimum standards. Okay? All the minimum standards. Walang problema. PhilHealth, SSS, Pag-ibig, binabayaran ko lahat yan. 13th month pay, bayad kayo dyan. I comply with the minimum standards of overtime pay, binabayaran ko yung mga holiday pay, etc., etc. Okay? Wala kayong reklamo. Okay lang yan kung halimbawa 1 year pa lang kayo in the employment, correct? Now, tanong, what if you had already been employed maybe for 10 years? And I had been giving you everything that is labor code, the minimum standard. Question, will you be happy? But am I doing anything wrong? You file cases against me? I'm complying with everything. Is there anything in the labor code which says that I have to give you more? Meron ba dyan sinasabi? O ngayon, yung want more? Well, you might have to organize yourself if you want to have. If I'm not, kung ganun lang ang gawa, minimum, am I doing anything that is violating the law? No, because I've been compliant. But then again, on your part, will you be happy? That's now, how will you force me to give you better benefits, better wages and benefits? How will you do that? There are ways. Okay. Isa-isa. Individual base, sumipsip ka. Fine. Butong naging favorite kita. What if not? Okay? So there's some who organize because they want to have better terms and conditions of work. Because management has not given them better terms of work. Pero minimum lang. So hindi na natutuwa na ngayon. Ang tagal-tagal na namin dito, wala man lang kayong acknowledgement. So, the reason why people organize themselves is that they will have better bargaining leverage with management so that they can have better terms and conditions of work, better salaries, okay, better benefits. Okay, so that's the reason for organizing. Okay, now, in fact, in that particular diagram that I gave you the first time, no, yung management, capital, profit, prerogatives on the left side, and then you have labor, you have work, you have the equitable share in the profits. As I said, remember, management is entitled to profits. The laborers, on the other hand, demand an equitable share in the profits. Why? Because if they had not worked in the manner that management dictated them to do so, then management would not have gotten the profits in the first place. Bigyan man kami dahil kung hindi kami nagtrabaho ng kasing galing, no? Ng dedicated, then you would not have gotten the profits in the first place. Bigyan mo naman kami ng konti, paambunan mo kami ng konting profit. But the labor code doesn't say how you're supposed to get that. Wala namang dinictate doon na the labor code na, management should give 30% of all of its net profits. Wala namang ganun, di ba? So, what does a labor code say? Well, you can organize yourself so that you can have bargaining leverage management in order that, you can do collective bargaining. That's when you can get your better benefits. Okay? Now, so going into this, there are actual mechanics and procedures that you have to do before you can actually create a union. No? So first of all, you have to determine only those who are employed in the company can actually unionize. So there must be an employer-employee relationship. So the existence of an employer-employee relationship is a condition sine qua non for the exercise of the right to self-organization. Okay? So now, remember our discussion last week? I had COVID cafe, I had my employees, and then I had also contracted out the job of security and maintenance to a third party. So I had security guards and janitors in the cafe. You remember that? And we said, not everybody who works in the COVID cafe are actually my employees. Now, in that instance, where these are employees of an independent contractor, the employees of the independent contractor, meaning to say this is a valid job contractor with IARM Free Capital Temwork R&B. Okay? Memorize na nyo yan. Pag nag-comply yan, ibig sabihin valid job contracting yan. Security guards and the janitors are not my employees. Question, can the security guards and the janitors join union in COVID cafe? Answer, no. Why? Because there is no employer-employee relationship. Ibahin natin kung labor-owned contractor la yung agency. In which case, there is no presumption of an employer-employee relationship. Okay? Ibahin natin yon. Independent contractor yan talaga Nagko-compliant yan sa Department or 174, may capitalization, no? He works for his own account, under his own responsibility, uses his own means and methods, free from the control of the principal except as to the results, and he has capital in the form of tools, equipment, machineries, and work premises, then that is presumed to be a valid job contracting arrangement, in which case his employees do not become my employees in COVID Cafe. Claro? Okay, so now, against all of my employees, kayo naman, who among you can unionize? Who among you can unionize? Let's say, for example, this is a rank and file union that you want to put up. Definitely, hindi naman lahat rank and file sa COVID Cafe, di ba? Dahil meron akong general manager, meron akong finance manager, meron akong options manager. Tapos meron akong HR supervisors. Okay, sa HR. Meron din akong operation supervisor. So, yung mga yon hindi pwedeng sumali doon sa rank and file union. So, let us now go one by one. Who can unionize? General rule. All employees in COVID Cafe can join a union. Exception. So, try to memorize now. Who cannot unionize? Well, the law says definitely government employees do not fall under the labor code. So definitely they do not. Okay? This will not apply to government employees. Except government employees, okay, of government-owned and controlled corporations without original charters because they're treated as private companies. Okay? In which case yon pwede sila. Now, managers cannot, by explicit provision of law, cannot form or join unions. Why? They cannot form their own union because it becomes, you know, an exercise in futility. They will just be bargaining with themselves. Bakit? Sila rin naman nagde-decide eh. Na? Now, supervisors cannot join with the rank and file union, but they can form their own union. The law explicitly says, okay, supervisors can form their own unions, but they cannot join the rank and file. So, kung rank and union ang gusto nung gawin, hindi mo pwedeng isama yung supervisor mo. Okay? Now, fourth, confidential employees. Sino yung confidential employees? Now, remember the definition of confidential employees. These are employees who have access to confidential information relating to labor matters. Okay? Now, these employees are considered as akin to management, right hand to ng management eh. So the Supreme Court is that confidential employees under the doctrine of necessary implication for the same reasons as for why management are likewise not allowed to form unions, then so should that particular rationale apply to confidential employees. Okay? So, in this instance, confidential employees are like management. Okay? They have access to confidential information relating to labor, for which reason they should not be allowed to join the unions. Okay, now, members of a cooperative. Bakit hindi sila pwede mag-unionize? Because members of a cooperative are likewise owners of the cooperative. And so therefore, they are actually leaders. And hence, they're not actually employees. Okay? They own the enterprise itself. In which case, therefore, they are also prohibited from forming their own union because it becomes an exercise in futility. Sila-sila rin mag-uusap. Claro? And then aliens and employees of the diplomatic corps. So general rule, aliens are not allowed to unionize. The only time they will be allowed to unionize is if they comply with two elements. Number one, the alien has a valid working permit. And number two, there is reciprocity, meaning to say that his country allows Filipinos there to join unions as well. Absent these two elements, the alien cannot be allowed to join a union. Okay? Now, you want to put up a union, as I said, because you want to have bargaining leverage with management. You want to be able to bargain with them in collective bargaining for the purpose of coming up with an agreement for better terms and conditions of work. However, remember, management is not under any obligation to negotiate with anybody except an exclusive bargaining agent. Meaning to say, nakadaan na sa isang proseso. So, hindi ako kailangang umupo sa harap ninyo. Kahit gumawa kayo ng union, no? You have to go through a process to prove to me that you are representing the majority of the members in that particular rank and file bargaining unit. So how do you do that? Well, first, you have to create a union first. Okay? You have to create a union. Now, on your part, if you're a rank and file employee, you want to think, okay, how do I create a union? Do I want to be an independent union? So you have two choices. Do you want to be an independent union or do you want to join in with a federation? Now, there are different requirements for these two. And there are advantages and disadvantages to each one. In an independent union, there are more requirements. Okay? But you are independent, meaning to say you will not be dictated upon by another entity. The downside of that is that if you are a new union, you are an independent union, nobody's going to teach. You have no support. Hindi mo kung anong gagawin mo. Wala kang padrino. Okay? But, you do it on your own. On the other hand, if you want to fast track things, the law allows you to federate, to affiliate with a federation, to fast track things because there are lesser requirements, only three requirements: a chapter certificate, and then your constitution and bylaws, and then the names of your officers and the addresses. Yun lang. And then once you have a charter certificate, then you're considered a union affiliated with the federation. What's the advantage of that? Well, you have support from the federation. The federation can actually teach you and can actually guide you as to, how will you bargain, what to do, what particular seminars, how will we teach our employees to be more aware of their rights as employees, etc., etc. Maraming pwedeng gawin. But what is the advantage? You have to comply with the constitution and bylaws of the federation. There are certain things that they can impose upon you, one of which would be a portion of your fees, your union fees will be remitted to the federation for the support that they give. No? Now, so there are lots of pros and cons there. Now, in any event, if you choose to unionize as an independent union, you will see that there are a lot of requirements. Maraming documentary requirements, no? And most of the documentary requirements will refer to one of the more important things there would be, aside from the names of your officers, your constitution and bylaws, the minutes thereof, the most important thing is that you have to show that you have a membership which is equivalent to at least 20% of the total membership in the appropriate bargaining unit. Okay? So kailangan mo mapakita yan na 20%. How do you know what is the appropriate bargaining unit then? Yun yung palaging problema. How do you use the appropriate bargaining unit? Will classification of employment play a role in the bargaining unit? Yung in terms of whether you're probational, you're casual, you're seasonal, you're regular, etc. General rule, no eh. Long you are an employee, as of the first day of employment, you have the right to join a union. Or even not to join a union, but theoretically you have a right to join the union as of your first day of employment, regardless of the classification of work. Okay? Now, What is important though is that you know the hierarchy. So again, you want to put up a rank and file union, you take out the managers, you take out the supervisors, you take out those people who are not employees, the janitors and the security guards in this COVID cafe. Whoever is left, that's the appropriate bargaining unit of the rank and file. So you count. How many is that? Let's say, for example, there are 50, para madali, 100 employees of the rank and file. Then how many signatures do we need? How many members do we need to be able to show to the Department of Labor when you want to register yourself that you have at least 20%? Then I have to have 20 signatures showing that I have 20 members. Okay? Now that is not a requirement in a affiliated, meaning to say a local chapter of a federation. Hindi mo kailangan ipakita yon because that is already presumed. The federation will check on that themselves. Okay? Now, um, a usual question in the bar now, because the bar has become more, uh, shall we say, a little bit more, yung mga distinctions, objective type na eh. So, I want you to study in more, not only just for the bar but for your classes. What is the difference between a labor organization and a legitimate labor org? Remember, not every union can actually have rights. It must be a legitimate labor organization, which means that the labor organization must have registered itself with the Department of Labor. Okay? Now, so distinguish between a labor organization and a legitimate labor organization. And then you distinguish also between a union as against an appropriate bargaining unit. Distinguish between the two. The union is the political. The appropriate bargaining unit is the, kumbaga in elections, the electoral body itself. Yung because an appropriate bargaining unit of the rank and file might be composed of members of different unions. Klaro? Kumbaga sa election, no? Merong nasyonalista, may liberal, merong kung ano-ano pang, nakalimutan ko na yung mga pangalan ng mga partido ngayon, iba-iba na, no? PDP laban, those are the unions. Pero yung buong voters list, yun yung appropriate bargaining unit. Okay? Yun lang yung parang mabilis yung matandaan. Okay, now, remember, if you want to federate naman, you want to be a local chapter, as I said, you only need three requirements. The chapter certificate, the names of your officers, and then the bylaws, okay, the constitution and bylaws. Now, for purposes of filing a petition for certification election, which will go into that later, no? Lumabas na to sa bar 2 years ago. The question was, can a local chapter already file a petition for certification election if the Department of Labor had not issued a certificate of registration yet? The answer is yes, because the law explicitly states that for purposes of filing a petition for certification election, okay, what is required is only a charter certificate coming from the federation. Okay? Now, what happens when you register yourself? Okay? The union is registered with the Department of Labor. Then the union is now considered a legitimate labor organization. It's not just an ordinary union, but it's now considered a legitimate labor organization. What happens? Then you acquire legal personality. For all intents and purposes, you are now considered to have legal personality, and you will now have vested rights to all of the rights that are found in the labor code. Okay? Now, when are you considered to have legal personality? Once that the certificate of registration from the Department of Labor is issued, then you have all of those rights, no? Now, what are what is the effect of registration? Again, the labor organization is now considered a legitimate labor organization and is now vested with legal personality upon the date of the issuance of the certificate of registration by the Department of Labor. Now, I cannot refuse to recognize you na. Okay? Yung legal personality nyo, meron na yan. Okay? And you can now demand certain things from me, like yung mga financial statements, etc., etc. Kung manalo ka sa petition for certification election, then you become an exclusive bargaining agent, then you cannot bargain with me. And I cannot refuse to recognize you. Okay? Now, what is the effect if you do not register yourself naman? Wala. You cannot bargain with me. So what is the point of coming up with the union if you cannot even bargain with me anymore for better terms and conditions? Well, ang gusto pala ninyo, gagawa lang ng social club. Okay? If you do not register yourself, you cannot bargain with me. So you are practically just a social club. Ano yon? Nag-uusap lang kayo kung kailan kayo mag-zumba. Okay? Or magbo-ballroom dancing. Or kung magkakaroon kayo ng field trip elsewhere pero hindi ko kinikilala yon. Okay? Now, so what are your rights? Once you become a legitimate labor organization, what are now your rights? So you have a right to go through, to file a petition for certification election so that you can prove to me that you represent the majority of the employees in that appropriate bargaining unit of the rank and file. Remember, rank and file pinag-usapan natin, ha? Now, once you become a legitimate labor organization, you have a right to demand of me the financial statements of the company. And you can you can now own your own property. Bibili kayo ng kotse, bibili kayo ng condominium unit kung saan nyo ilalagay yung office ninyo. You can do that if you have money, enough to purchase all of those things. Okay? Now, remember, paano kung halimbawa, may situation na ganito, may union, tayo kayo ng rank and file, okay? 100 kayo, rank and file, tapos, na-register nyo na sarili nyo. So, you are now a legitimate labor organization. Then, marami akong na naging supervisor. Say, out of that 100, of your rank and file members, I promoted 20. Question. If you file a petition for certification election, because you already want to bargain with me, di ba? So mag-file ka ng petition for certification election. Sabi mo, ma'am, I want to find out. Let us go for an election so that we will find out if we're majority. We believe we're the majority so that we can bargain with you. So nag-file ka ngayong petition for certification election. Question. Can I file any motion to cancel your union registration on account of the fact that you have many supervisors within your membership? Ha? Pwede ba? Now, there are several answers to that. Number one, if this is a petition for certification election, I cannot question your status as a legitimate labor organization. Okay? Because your legal personality has already become vested by the issuance of that certificate of registration. Secondly, the fact that you have members you have supervisors within your membership now. That is no longer a ground for the cancellation of union registration. Okay? So, the inclusion of membership of union members, of employees who are no longer rank members, that is not a ground for cancellation of union registration. In fact, the law now says that the employees, yung mga naging supervisors, are deemed automatically removed from the list of membership of your rank and file union. Okay? Now, I want you to memorize lang. Ito lang, wait lang. Yung grounds for cancellation of union registration. No? Hindi pa natanong uli ito for the last 2 years, no, sa bar. Anyway, yung grounds for cancellation of union registration, tatlo lang yan eh. Dati kasi 16 or 17. Now the Congress has whittled it down to just 3. So it's easy to memorize. Just memorize all these 3, and whatever is not there, then you cannot cancel. So memorize mo lang. Misrepresentation of false statements or fraud in connection with elections, okay, of officers, misrepresentation or fraud in connection with the ratification and bylaws. And the third would be voluntary dissolution of members. Okay, this is when you yourself decide that you want to dissolve your own union. That's a new mode, no? At that time. Okay. So, the requirement in voluntary cancellation of registration of a union. Halimbawa, gusto nyo na lang tanggalin na yung union ninyo. Nawala na kayo ng gala mag-unionize. 2/3 of the general membership must vote to dissolve that particular union. 2/3. Hindi majority. 2/3 of those in existence. Okay? Now, so, question. Can the employer cancel? Can your employer move for the cancellation of the union registration? The Supreme Court has already come up with a decision that the provision that employer is simply a bystander. The bystander rule only applies to petitions for certification, but not to the petition for cancellation of union registration itself. That is the case of AIM versus AIM Employees Union. That had just been asked in the bar. So I don't think that will be asked again. No? But anyway, just for your process, for those who are not taking the bar, but for those who are just taking labor relations, remember, no, the employer bystander ruling, no, provision in the labor code is interpreted by the Supreme Court now from a very strict perspective. It is, ang sabi lang dito kasi, no, the employer as a bystander can only in cases of petitions for certification election and not in the actual petition for cancellation of union registration. Okay, it is only with respect to petitions for certification election. Claro? Okay, so now, I'm presuming that you understand the difference between managers, supervisors, and rank and file. No? Nandiyan na yan sa notes ninyo. So, basta yung manager, alam niyo na yung manager. Yun na yung mga boss chief. Okay? Those who are vested with the prerogative and the powers to create and to implement rules and regulations. On the other hand, yung supervisors naman, ano yung difference na yun? Those who have effective recommendatory powers only. No? Effective recommendatory powers to lay down policies. But they cannot implement it immediately. Okay? It is just simple, effective recommendatory powers. But remember that the exercise of powers, the exercise of those authority is not merely routinary or clerical in nature but needs the use of independent judgment. In short, halimbawa, sa COVID cafe, sinabi, ay walang pasok ngayon. Sabi ng supervisor, uuwi ba kayo agad? Hindi, alam nyo. Alam nyo hindi kayo uwi agad. Bakit? Bisor lang yan eh. You have to go to confirm with the managers, the GM. Because sila talaga yung boss chief. Because they have a right to lay down, to create, and to implement the policies. Whereas kung supervisor yan, alam mo lang na recommendatory lang yung power niya. To say na, ay, hindi tayo papasok ngayon. Clear? Okay. Now, let us now talk about appropriate bargaining unit. Paano malalaman kung talagang member ka ng appropriate bargaining unit? Ha? So, sabi ko sa inyo kanina, take out the managers, take out the supervisors, take out the members of the employees of the security agency and the janitorial agency kasi independent contractors yan. Sino pa tatanggalin? Tanggalin nyo yung confidential employees. Confidential employees in the same manner as managerial employees under the doctrine of necessary implication. The Supreme Court said they should likewise be deprived of, they cannot exercise the right to self-organization. Okay, for as long as they have access to confidential information relating to labor matters. O sino pa tatanggalin? Question. Paano yung empleyado na na-dismiss, na nag-file ng kaso? Member pa ba siya ng appropriate bargaining unit? Ha? Halimbawa yung barista kanina, dinismiss ko. Pero nag-file siya ng kaso questioning the validity of the termination. Question, is he considered an employee for all intents and purposes so that he can be counted in as member of the appropriate bargaining unit? Answer, yes. The labor code explicitly states that this is an employee. An employee is one whose employment has been terminated but who has questioned the same in a proper proceeding. Okay, nandun yan sa Article 219, paragraph M of the Labor Code. Okay? Now, so let's now go into certification election. Bakit pa importante to? Because that's the last step before you can bargain with me. You have to prove your majority status. Okay? So now, what do? You will have to file a petition for certification elections. And what is a certification election? A certification election is simply a procedure to determine who is the majority union. No? Who is the majority union? Do you represent a majority of the employees in the appropriate bargaining unit of the rank and file? If yes, then, okay, you will be certified as the exclusive bargaining agent. Now you will have a right to bargain with me and I cannot refuse. Yun ang ibig sabihin nun. Bakit? Remember what I told you earlier? Unless you can prove yourself as the majority union, I have no obligation to deal with you. Kasi hindi naman ako pwede mag-bargain sa minority eh. Diba? Makakapag-bargain lang ako sa majority union. Okay? Now, so, how do we determine if you are the majority union? There are 4 ways actually that are provided for, not provided. There are 3 ways in the labor code. No? Dati merong isa 4th way pero bawal na. Anyway, let's discuss it. The general rule is that certification election is the best way to determine if the rank and file employees want this particular union as the majority union to represent them in collective bargaining. Okay? Remember, you want to bargain with me so that you can have better terms and conditions of work. Hindi lang minimum standards, di ba? Ayaw nyo ng minimum lang eh. Gusto nyo mas marami. Gusto nyo tigi-tigisa kayo, meron kayong kotse. Halimbawa, gusto niyong i-bargain yan, fine. Sige, mag-CBA tayo. But you will have to prove yourself to be majority union. Okay? Now, what are the other ways? Other ways are consent election, direct certification, ito yung pinagbabawal, and then yung tinatawag na SEBA, sole and exclusive bargaining agent. Now, what is consent election and how do we distinguish that from certification elections? Yung consent election, okay, the presumption here is that there are two contending unions. Okay, there are two contending unions and both agree just to have elections. In short, the government does not have to step in and decide, sige, mag-hold tayo ng election. Hindi. As between the two unions, they already said, okay, wag na tayo mag-file ng mga oppositions, objections, etc. Let's just make the best union win. Yun lang, simplistically yung ibig sabihin ng consent election. So the med arbiter does not even have to decide, and they just put in the minutes in the constancia that these two unions have consented to an election. But the mechanics of the election are still the same. Okay? Now, direct certification, ito yung pinagbabawal na. Bakit? In this instance, the employer before was allowed to determine who the majority union is. Okay? The Supreme Court said you cannot allow the employer to arrogate in unto himself the right to determine who the majority union is, because that is ultimately an employee's right. Okay? That is your right. Bakit ko naman paghihimasukan pa yon? Hayaan mo nang sila. Besides, that is very fraught, that could be abused very well by the management. Bakit? Kung ako pala yung may karapatan, if I have the right to determine who the majority union is so that I can bargain with him, who will I choose? I probably might choose a company union, which is actually prohibited. Bakit? Because in that instance, that union, yung sip-sip na union, will be in all probability looking after the interest of management rather than the employees whose interest they're supposed to protect. That's why it's prohibited. Okay? Now, third, we call it the sole and exclusive bargaining agent. This used to be what is called voluntary recognition. However, that exercise, yung voluntary recognition as a procedure was not very successful because no employer wanted to make use of that particular mode, no? So yung certification election yung pinaka common, no? In which case the government now during a proceeding will now say to the med arbiter, sige, let's just hold the certification election. So this is merely a process of determining through secret ballot who is the sole representative of the employees in the appropriate bargaining unit for purposes of collective bargaining. Okay? Now, so let's move forward. Yung SEBA, I think my slides will already clarify to you, no? Yung SEBA, nandyan na yung mga requirements. Remember only that in SEBA, sole and exclusive bargaining representative, there must not be any other union existing in the appropriate bargaining unit. Example, yung pangalan ng union, Panalo Union, wala nang ibang union doon. So ngayon, pupunta na ngayon siya sa Department of Labor, sasabihin nila, i-recognize niyo na kami. Because we're the only legitimate labor organization of the rank and file here. So in as much as we're the only union in this particular rank and file appropriate bargain, recognize us so that we can now bargain with management. So that is SEBA. Who has the power to recognize? It's the regional director. Provided that the union, the legitimate labor organization, has complied with all of the requisites. No? So the requisites are already outlined, enumerated in your slides. No? There. So let's now go into inter-union controversies. Ano yung inter-union controversies? Ito yung dalawang union na naglalaban. So, usually yan, it's either cancellation of union registration ng mga kaso or sino yung majority union in certification election. So let's now go into one situation. I think I put that there in one of your slides. So let's call this, let's make it a COVID cafe instead of COVID school na lang. O sige, COVID school. COVID school or COVID cafe. We are unorganized, meaning to say there is no existing CBA. Bakit? Hindi pa tayo nagbabargain, di ba? Kagagawa lang ng union ninyo eh. Okay, now. Pero hindi lang yung union ninyo. Meron pa palang isang union. So your union is called Panalo Union and the other union is called ASAPA Union in this COVID school. Question. Okay? So that's the scenario, ha? Question. In this particular scenario, no existing CBA, bagong parehong union, sino pwede mag-file ng petition for certification election? Sino? Which union? Answer, any one of you, unahan kayo. Either Panalo or ASAPA Union can file the petition for certification election. When? When they file? Anytime. Bakit? Wala pang CBA, so there's no freedom period to talk about. Okay? Now, question. Panalo Union files a petition to declare itself as a sole and exclusive bargaining agent. Yung SEBA, ginamit niya. Question, will that SEBA procedure be allowed in this case? Huh? Answer, no. Why not? Ito yung union, di ba? There's Panalo Union and there's ASAPA Union. We're assuming that they're both registered, legitimate labor org. In that case, there are two legitimate labor organizations existing in the same appropriate bargaining unit of the rank and file. SEBA cannot be made. Okay? Hindi pwede mag-declare ng sole and exclusive bargaining agent. Bakit? Hindi nga siya sole eh. Okay? Now, what will happen? Well, that regional director, once he receives that SEBA, will now refer the same to the med arbiter for certification election. Okay? Now, question. Same scenario. Kalimutan nyo na yung SEBA, pero ito, nag-file ng petition for certification election yung Panalo Union. Sinabi natin they can file anytime, no? Okay, question. How many consent signatures have to be given? Kailangan ba may ipakita pa na signatures na, eto marami, gustong magpa-petition for certification election? Kailangan ba? Answer, no. There is no requirement to prove that there are at least 25% of the members in the appropriate bargaining unit. Bakit? Wala pang collective bargaining agreement eh. Diba? Wala pang freedom period. So, kailangan ng consent signature requirements. Na? Okay, so let's now go for the second situation. The second situation says, there was a CBA executed between, okay, so nanalo na. Let's say in this example, tuloy natin. Nag-certification election, nanalo yung Panalo Union. So, COVID Cafe versus Panalo Union in a collective bargaining agreement. Okay? Nag-bargain tayo. Pak. So, you now have more than, you have benefits which are more than that provided for by the labor code. So, you were able to negotiate with me for better terms and conditions. In fact, you have higher than minimum wages now. Now, take a look at the terms of this particular contract. Nakalagay dito. This CBA executed by and between COVID Cafe and Panalo Union shall be effective for the following terms. A, for the economic term from January 1, 2015 to December 31, 2018. B, the representation term from January 1, 2015 to December 31, 2020. Okay? Kita nyo na? Nandiyan sa slides nyo. Tanong. Tanong. Kailangan ba dito when is the freedom period here? In this situation. Where do you count the freedom period here? Yung January 1, 2015 to December 31, 2018 or yung January 1, 2015 hanggang December 1, 2020? Okay. What is the freedom period? The freedom period is the 60-day period prior to the expiration of the representation issue of that CBA. So which means yung 5-year period. No? So, you look at it 60 days prior to December 31, 2020. Clear? Okay. Assuming umabot na tayo sa freedom period. What is the freedom period here? So, November 1 or November 2, 2020 hanggang December 31, 2020. Check ninyo yung 60-day period. December 31 being the 60th day and then count back. Okay? That's the freedom period. So you file the petition for certification at any time between the two dates, December 31, 2020, and then work back, November 2, 2020. A time in between those two dates. Okay? So pwedeng November 2 all the way to December 31. But anything outside those two, outside the freedom period na yan. Question. Panalo union kayo, kayo yung nanalo, majority union kayo. Who files the petition for certification election? Sino magpa-file na petition for certification election within that freedom period? Kayo ba? No, of course not. You will not file. Why? You're the Panalo union. You're the union eh. So your majority status will continue for as long as it is not challenged. So who files the petition for certification election? During the freedom period, it is the challenging union. So in this instance, sino yung magpa-file? Dapat ASA pa union or kung meron pang ibang union na biglang na-create at naging na-register in between those 5 years. Clear? Okay? Now, question. Kailangan ba ngayon ipakita nung ASA pa union yung consent signature requirements? Do you have to comply with the 25% consent signature requirements? Yes. In this instance, yes. How many percent again? 25. Bakit? Bakit 25%? Ba't hindi 20? Ha? Remember, all of the registered unions are presumed to have 20% membership. At the very least, 20% membership. If you want a union, that majority union is presumed to have at least 20%. So you want to challenge, then you show, I have more. That's why it's 25%. Claro? Huh? Okay, good. Now, so let's just go back. So you now, ASA pa union now files this petition for certification election during the freedom period at any time between November 2, 2020 until December 31, November 15, 2020. Question, is that within the freedom period? Yes. Will that particular proceeding petition be allowed? Yes, for as long as they comply with the 25% requirement. Okay? So let us assume that ASAPA Union complied with all. So it files within the freedom period and submits the 25 signature requirement. Sabi niya, oy, I have people, membership of at least 25% who want to challenge panalo. Now, this is what happened. Your president, the Panalo Union president, let's call him Roy. Roy says, ASAPA Union, I want to disqualify him. I want to disqualify ASAPA Union. So he files a petition questioning the union registration of that ASAPA Union. Yung president nyo, final yung nag-file ng motion to disqualify ASAPA Union during that petition for certification election. On the ground that, yung ASAPA Union, it has both confidential employees and supervisory employees within its membership. Question, if you were the mid-arbiter, how will you rule on the motion? Will you disqualify ASAPA Union? Answer, no. Okay? Motion denied. Number one, this is not the right venue. If at all, okay, they have the personality, the legal personality of your union, of ASAPA Union cannot be questioned collaterally, cannot be collaterally attacked in a petition for certification election. If at all, they have to file a separate petition for cancellation. Okay? And get that decision before the certification election itself. But please take note, there's an important answer and it's more correct. Ano? Katulad yung sinagot natin kanina. The fact that a registered union has both supervisory and employees is no longer a ground to cancel the union registration. Bakit? Those supervisory members and confidential employees will simply be dropped from the membership roll. And then the petition for certification election will just continue. Now, kung ikaw ngayon yung majority union, di ba kayo yung panalo union? Okay. Gusto mo i-disqualify yung ASAPA union. Ano yung mga grounds na pwede mong erase? What are the particular grounds that you can raise? So that you can disqualify ASAPA union. So that you will remain majority union. You don't want to let go of that majority status. What are the grounds? So you now have 5 grounds there. First, ASAPA Union, if you're able to show that ASAPA Union is not registered pala. So differentiate that with union registration should be cancelled. Hindi. Ito talaga wala siyang certificate of registration. That's one ground. Second ground, they filed it within the freedom period but they were not able to show 25%. Okay, the 25% requirement. They were not able to show that they have membership of at least 25% of the membership in the appropriate bargaining unit that wishes to have a petition for certification election. And what's the third? Eh di yung katulad kanina, failure to file within the freedom period. What do you call that? That's called the contract bar rule. You can only file a petition for certification election within the 60-day period prior to the expiration of the representation term of the collective bargaining agreement. Okay. Fourth, the 1-year bar rule. What is the 1-year bar? You cannot file any petition for certification election within 1 year from the finality of the certification results. Okay? Ano ibig sabihin nun? Makalo ko ba mayroon contract bar? O ito 1-year bar eh. Ano nangyari doon sa 1-year bar? In the previous certification election, sinong nanalo? Walang nanalo. Ang nanalo dito, okay, no union. So, kung nanalo doon, no union, within a 1-year period, you have to respect the wishes of the majority of the employees in the appropriate bargaining unit. Ayaw nila yung majority. Ayaw nila kahit sinong union as a majority union. Bakit? Remember, sa kahit anong petition for certification election, sa kahit anong election, ha? You have the right to choose a union or not to choose a union, in which case you say no union. So, a default vote is always no union. So, halimbawa, panalo union, ang majority union, sa pa union is a challenger, ano makikita sa ballot? What will be shown in the ballot of that certification election? There will be 3 choices. What are the 3 choices? No union, panalo union, and asa pa union. Okay? So in this COVID cafe, rank and file employee, when he goes to that election, can choose either no union or choose panalo union or asa pa union. And then you have the third. What is it? The deadlock bar rule. Which means that even if this was the freedom period, if there is already an impending strike, then any petition for certification election will not be entertained. Okay? Will not be entertained. Okay. So now, there are questions? Okay, is the labor code also applicable to the government employees? No, as a general rule, government employees do not fall under the labor code. They are governed by the civil service code, and in respect of the wages, you're not bargain kasi for wages in the government eh. May salary standardization law. That's why they are precluded from bargaining for terms and conditions which are fixed by law. That's why their CBA really different, no? Now, there are employees who are contractual for years. Yes, that's okay. Alam mo, sa totoo lang, ito sasabihin ko na talaga sa inyo, the government is actually the worst, you know? Because some of them, some of those people in the government offices, they have been there for the longest time. So there's something that has to be done, I suppose. But that's the government eh. I cannot, there are various reasons. You have to, para ang pagkakaintindi ko kasi sa government pag nasa civil service ka, you have to fix the plantilla pa. And it has to go through a whole lot of process bago magkaroon ng, halimbawa, dadagdag ng tatlong, let's just say, legal researcher. Hihingi ka pa muna, ang daming proseso eh. No? Kaya nagtatagal yan. Okay. How about doon po sa employment practices sa mall? End of contract after 6 months, then renew na lang. Okay. Alam mo, ito yung pinag-usapan natin ng last meeting, no? We have to check yung dito sa NDOC. You have to check first, is that an independent, a valid job contracting arrangement or not? Because once the contract between the principal and the contractor ends, definitely nag-end din yung data nung empleyado ng contractor. Hindi na siya pupunta doon. Halimbawa, COVID cafe, meron tayong mga security yung security agency ngayon, nag-end na yung contract namin. Ano mangyayari doon sa security guards? Now, the security guards remain to be employees of the security agency. The law now under Department Order 174 says the obligation, there is an obligation on the part of the security agency if the security guards are regular employees of the security agency to look for alternative work for the security guards that no longer that had already that had been deployed to COVID cafe. So, meron dyan tinatawag na floating status. Ang maximum ng Department Order 174 is a period of 3 months. Okay? Period of 3 months that the contractor, the security agency, will have to look for another client with deploy the security guard too. Okay? But that's quite a very complicated matter, especially now with the COVID, no? Kasi marami talagang naipit because of this COVID. So this is considered a force majeure. Now, not of payment of 13th month pay. Okay, we'll just have to let us focus on questions regarding this petition for certification election and yung mga napag-usapan na natin kanina. Sasagutin ko na lang yung iba sa messenger. Okay. Personnel of accounting department, is it considered a confidential employee? How about secretaries of the president or members of the board of the company? Can they be classified as confidential employees? Okay. Number one, again, the definition of confidential employees are those who have access to confidential, who occupy a confidential position and who have access to confidential information relating to labor matters. So, yung accounting department, it all depends on whether or not they have access to confidential information relating to labor matters. Meron ba silang access sa mga payrolls? Okay? Or yung doon sa mga 201 files. Yan, definitely yung mga HR, confidential yan. What about the Secretary of the President? Yes, that is considered a confidential employee. What about the Secretary of the GM? Yes. What about members of the board of the company? The secretaries of the members of the board of the company? Yes. They will have access to confidential information. Okay? Okay. Is it legal for an employer to have their employee contract that will prohibit them to form or organize a union? That is prohibited. That is an unfair labor practice. Okay? Ang tawag dyan, yung yellow dog contracts. That is explicitly stated in the labor code that the management cannot force the employees to sign any contract with a stipulation stating that they will not exercise the right to self-organization. Okay? Now, let's now go into, okay, so tama-tama, unfair labor practices yon, no? So, yung unfair labor practice, mamaya na yon. Baka tayo magkuhan sa oras, kailangan ko pa ng 4 p.m. na. Tapusin ko lang yung certification election, tapos siguro, pwede tayong bumalik pa for a third time, for strikes. Strikes, picketing, lockouts, at saka siguro dagdagan natin ng termination or labor standards, na? Okay. Teka lang, ipaalam ko pala muna sa PALS. Okay. Now, tingnan natin yung certification election. Huli na to. Ito na yung last portion. Nagtagal pala ako dun sa classification of employment. Sayang. Sorry medyo ginanahan ako dun eh. Okay. Now, yung importante sa certification election is to determine who won. Di ba? How do you know who won? So, how do you determine who won in election? So, remember again, COVID cafe. And then, rank and file bargaining unit. So, kayo, mga rank and file employees, sino-sino yon? yung barista, yung kahera, yung stockman, yung waiter, yung dishwasher, yan, rank and file lahat. Yung mga bisor, hindi pwede. Yung managers, hindi pwede. Yung confidential employees, yung personal, yung secretary ko as boss chief, hindi siya pwede. Tanggalin nyo yun. Tanggalin nyo rin yung security guards at saka yung janitors kasi merong agency yon, independent contractor, tanggal din yon. So kung sino iwan yun yung rank and file. Klaro? Okay. Now, sa certification election, how do we determine who won? So there are two requirements here. Number one, you have to show that there is a majority of the rank and file employees in COVID Cafe that actually voted in that election. So let's say 100 nga kayo, di ba? 100. At least 51 must go the election proper and cast their votes. Nagboto. Hinulog yung balota doon sa ballot box. 51 minimum. Second, majority rule says who won. The first majority rule, a majority of the members in the appropriate bargaining unit cast their vote. That answers the question, is there a valid election? Okay? So, is it election? Then, to find out if there is a valid election, there must be majority of the employees in the bargaining unit that shall have voted, shall have cast their vote. Now, the second majority rule answers the question, who won? Who is the majority union? The second majority rule says, the union which gets a majority of the valid votes cast in that election wins as majority union, or which is actually called exclusive bargaining agent in the labor code. So let's use the proper term, the exclusive bargaining agent. Okay? So now, question. May non-union members vote in a certification election? So, example, itong si Joy, ano siya, receptionist dito sa COVID Cafe. Hindi siya member ng Panalo Union. Hindi siya member ng ASAP Union. Non-member siya. Rank question, will she be allowed to vote in the certification election? Answer, yes, of course. For as long as you are a rank and files member of COVID Cafe, still participate in the certification election because you don't need to be a union member to vote if you want to have a union to bargain for you. Okay? Gusto mo ba na magkaroon ng union na bargain for you? Yun lang naman ang tanong sa certification election eh. Okay? Now, question. Halimbawa, itong si Paulo nga, na-dismiss. Siya yung barista kanina, di ba? Na dinismiss ko and he filed a case. He filed a case questioning the validity of his termination. He goes, barista siya sa COVID, he goes to the certification election. Can he be allowed to vote? Answer, yes, he can be allowed to vote for as long as he can show that he filed an illegal termination case. Okay? Sabi, halimbawa, pumunta siya dun sa certification. Sabi nung member ng panel. Sabi nung HR, dinismiss na namin yan ah. Sabi niya, nag-file ako ng kaso. Asan yung proof mo? Dinala mo ba yung file? Sabi ni Paulo, sorry ah, I could file. I did not know that I was supposed to show proof that I had filed an illegal termination case. But it is understood, as far as we're concerned, under the labor code, a dismissed employee who has filed a case questioning the validity of the termination is presumed to be and is considered an employee for all intents and purposes under the labor code. So, can he be allowed to vote? Yes, he will be allowed to vote. But what will be done to his vote? What will we do to his vote? Well, then his vote will be segregated in a separate envelope. Okay? Name there, and then segregated from the rest of the others. Okay? He will be considered a qualified voter, but his vote will be segregated because he could not prove. And his status as an employee was already questioned. Okay? So again, in case of disagreement, or halimbawa, ito ngayon si Lisa, si Lisa na-promote ko na sa supervisor. So, nag-object ngayon yung ASA pa union, it cannot be because this person is already supervisor. So, question, if there is a disagreement of the voters, what will be done? Now, in case of disagreement, again, all contested voters shall be allowed to vote, but their votes shall be segregated. Okay? Kung halimbawa hindi talaga, yung panel hindi man ma-determine, ano talaga, naging supervisor na ba to o hindi? Sabi ng management, hindi. He is just hindi yan supervisor, rank and file pa rin yan. Okay? So, halimbawa, ganun ang mga nangyari. Okay, now, question. So, let's not put it into a situation now. Let's now go for situations. So, sabi natin, 100 members in the appropriate bargaining unit of the rank and file. So, 100, para mabilis mag-count. Okay, now. Doon sa 100, ang pumunta doon sa election, ganito, lumabas yung results. Union A, 40 votes. Union B, votes. No union, 2 votes. And then the rest, hindi pumunta. They did not vote. Question, was there a valid election? What is the total? 47 votes. Was there a valid election? No, there was not. Why? Because they lacked 4 votes to make it a valid election. Remember the first majority vote, it said there. A majority of the employees in the appropriate bargaining have cast their votes, must have voted. Ilan lahat nagboto? 47 lang. Kulang sila ng 4. Okay? So, ano mangyayari? I-repeat lang yung election. Okay? There's a failure of election here and then they will just repeat the election. Okay, now, let's now discuss yung second majority vote to determine who won. Okay? Now, again, the union which obtains a majority of the valid votes cast, there's my cat, will be certified as the exclusive bargaining agent, wins as the majority union, in short. Okay? So now, the union that garners a majority of the valid votes cast wins the election and is now called the exclusive bargaining agent. Okay, so now, situation. Again, 100 rank and file employees, appropriate bargaining unit. Union A got 40 votes again. Union B got votes. No union got 2 votes, but there were 10 illegal votes, plus 10 illegal votes. And then the rest stayed at home and did not vote. Question, was there a valid election? Answer, yes. Why? Because here, there were 457 votes. Hindi naman kinakount dito kung valid or illegal, valid or invalid votes eh. Tinatanong lang ba, ilang bumoto? So, 40 plus 5 plus 2 plus 10 equals 57. So, may valid election ba? Yes, lumampas sila sa 51 eh. Question, who won? O sinong nanalo? Ang sabi dito, the union that garnered a majority of the valid votes. Ano yung valid votes dito? 40 plus 5 plus 2. Kasi yung 10, illegal votes. So, 40 plus 5 plus 2, 47. Ilan dapat ang makukuha nila? How many votes in order to win? So, a majority of 47 would have been 28. Check nyo lang. So, anyway, 40 is a clear majority. So, yun in this instance. Here? Okay, now last. Ito ngayon yung pinaka nakakalito. Marami nagkakamali. Run-off elections. Okay, what is run-off election? So remember and please try to memorize na lang yung requisites for run-off election. Ha? 3 or more choices. So remember, number 1, there are 3 or more choices. So in technical terms, 3 choices. Ano yung default choice natin? No union. So, anong ibig sabihin? Meron at least 2 unions na naglalaban. So, 3 choices, no union, panalo union, asa pa union. Clear? Element number 2. So, number 2. First majority rule is complied with. The first majority rule is complied with. So, there was a valid election. A majority of employees in the appropriate bargaining unit cast their vote. So the first majority rule was complied with. Number 3 element. However, the second majority rule was not complied with, meaning to say, not one of the 3 choices received a majority of the valid votes cast. No one. Okay? No one won. Because they did not receive the majority of the valid votes cast. Element number 4. Element number 4. The total number of votes for all contending unions is equal to at least 50% of the number of the votes cast. Ibig sabihin, ika-count nyo lang yung votes ng Panalo Union, ng ASAPA Union, and then pag na-total nyo na yon, it must be at least 50% of the total number of votes cast. Okay? Yan ang pinaka-importante. Diyan marami nagkakamali. Remember, it's the votes cast, hindi valid votes cast, but the votes cast. And then last element, you will now have a runoff between the 2 unions with the highest number of votes. Remember, no union is not a union. It is just a choice. Okay? So memorize that. Na? So now, that ends our discussion for certification elections. I promise that I will go through the questions in your comment page and try to answer you in your FB. Ha? Ganun na lang kasi hindi ko nakikita. Now, I will ask the PALS if it were possible to have a third lecture kasi hindi ko natapos yung strikes. Strikes and then some issues on COVID siguro, yung labor standards. Maraming nagtatanong kasi. So aside from strikes, yung baka pwede natin pag-usapan din termination, no? So I will ask for a third lecture if you want. I will be very willing and available, no? We'll just schedule it some other time. Hopefully we are able to finish this ECQ by May 15, babalik na sana tayong lahat sa school. So parang ang balita ko yata, parang ang schools will be the last no? The last category of those that will be allowed to go back. So in the meantime, pagtiyagaan muna natin itong online Facebook. I hope I was able to clarify certain concepts with you. I hope that we made it. We, you please thank you very much for listening, and then uh, do keep in touch. Look out for the next lectures. I think Dean Nivia will be coming in April 30. And somewhere after that, I think would be Dean John Largo for torts and damages. Okay? So maraming salamat po. I hope to see you next time. Kung papayagan tayo for a third installment of labor law. Uh, thank you very much. Have a good day. Bye-bye.